হ্যালো, হ্যালো, শুনতে শুনতে পাচ্ছ? হ্যালো,
হুম 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 বলো।
বলছি
শোনা যাচ্ছে, শোনা যাচ্ছে। হ্যাঁ।
ম্যাডামের স্মার্টফোনে প্রবলেম আছে, তো ম্যাডাম মানে
ও
দিতে পারবে। কালকেই তো লিখেছিল মনে হয়, আমি যতদূর
হ্যাঁ হ্যাঁ, তাও
মনে
একবার
করছি।
জাস্ট বলে নেওয়া।
আমার মনে, আমি ভুলে গেছিলাম, আমি না হলে তো বলতে। আহ,
ওকে,
প্রসেনজিৎ দা,
স্টার্ট
হ্যালো,
রেকর্ডিং।
পিডি করি না না,
হ্যাঁ,
প্রসেনজিৎ
এক
দা,
মিনিট এক মিনিট
চলে
দাদা।
যাচ্ছে। হ্যালো,
দিদি আছে।
আছি আছি দাদা।
প্রসেনজিৎ দা, হ্যালো,
এক মিনিট।
আমি দিদিকে কল করছি না।
পিডিকে কল করো তো।
হ্যাঁ হ্যালো। হ্যাঁ হ্যাঁ করে দিচ্ছি, সেটা ঠিক আছে, কিন্তু ইউটিউবটাও হয়ে গেছে। হ্যাঁ, ইউটিউবে এখন ব্রডকাস্ট হচ্ছে। শাশ্বতীকে আমি বলেছি একটু দেখুন, শাশ্বতী ওই দিকটা খেয়াল রাখুক, যদি কোনো সমস্যা হয়। শাশ্বতীর তো আগে কিছু নেই আপাতত। হ্যাঁ, তো শাশ্বতী
প্রসেনজিৎ দা,
ব্রডকাস্টটা দেখতে থাকুক
চলে গেল।
ইউটিউবটা। আরম্ভ
ফোনে
করে
আছে,
দিই এবার।
ফোনে আছে।
2 মিনিট
ও
একটু
আচ্ছা,
টাইম দেবেন। হ্যাঁ, 2 মিনিট
মনে
একটু
হলো
টাইম
ফোনে
দিন।
কথা বলছি।
আসলে দুটো একসাথে চলে, তো তাতে কি হয় আপনার মানে ভীষণ স্লো হয়ে যাচ্ছে। হ্যাঁ, দুটো একসাথে চললে একটু স্লো হয় আর কি। যাই হোক, ম্যানেজ হয়েছে,
করে দেবো।
আস্তে আস্তে ব্যাপারটা সরগর হচ্ছে আর কি। ইউটিউবে
রেকর্ডিংটা
কালকে
স্টার্ট
করা
করতে
যাবে,
হবে।
না,
সুন্দর আসছে।
বেসিক্যালি ব্যাপারটা ম্যাডাম বললো যে প্রসেনজিৎ দাকে বলে রেখেছে,
আমি আমার ডেস্কটপে
এই
খুলে
জন্যই
রেখেছি
আমি
ওটা।
জিজ্ঞেস করছি
ও আচ্ছা,
এটা শুরু করবে নাকি,
খেঁচান আছে প্রচুর।
এই জন্যই।
ঠিক আছে।
ওকে।
হ্যাঁ হ্যাঁ।
দিদি আর ইউ দেয়ার?
দিদি আর 2 মিনিট পরে শুরু করছে বললো। ঠিক
আচ্ছা,
আছে।
আচ্ছা, হ্যাঁ হ্যাঁ।
হচ্ছে তো। প্রেজেন্টিং না মানে আরম্ভ করিনি, তুমি লিস্টে দেখতে পাচ্ছ তো? হ্যাঁ ঠিক আছে। হ্যাঁ, পরেরটা এখন আরম্ভ করিনি। না না, ওইগুলো এখন আরম্ভ করিনি। না না না, এটা একটা দিয়ে হ্যাঁ, এবার আরম্ভ করুন। 2 মিনিট পরে যে যখন দেখবেন যে রেকর্ডিংটা আমি স্টার্ট করেছি, হ্যাঁ, উপরে লাল লাল কালারটা হবে। আজকে কালার কার আরম্ভ করার কথা, এটা তো আমি জানি না। কার আরম্ভ করার কথা একটু বলে দেন।
হ্যালো
হ্যালো,
হ্যালো। হ্যাঁ বলছি, আরম্ভ যার করার কথা, প্রসেনজিৎ রেকর্ডিং শুরু করলে সে আরম্ভ করুক, তারপর প্রসেনজিৎ বলবে।
রেকর্ডিং তো
ঠিক আছে।
প্রসেনজিৎ, হ্যালো,
হ্যাঁ বলো।
রেকর্ডিং তো প্রসেনজিৎ শুরু করবে।
হ্যাঁ করেনি তো এখনো।
অ্যাঙ্কারিংটা কে করবে? রেকর্ডিং শুরু করলে অ্যাঙ্কারিং যার করার কথা সে শুরু করবে, সেটা বললো, তারপরে ও
হ্যাঁ,
বলবে।
কি অ্যাঙ্কারিং কি বুঝলাম
ঠিক
না।
আছে।
ওকে,
হ্যাঁ,
তুমি অ্যাঙ্কারিং শোনো, তুমি অ্যাঙ্কারিংটা শুরু করবে, ম্যাডামের পার্টটা প্রসেনজিৎ করবে।
ঠিক আছে ঠিক আছে ঠিক আছে ঠিক আছে, বুঝতে পেরেছি।
হ্যাঁ হ্যাঁ হ্যাঁ।
অন দ্য বিহাফ অফ কলেজ প্রসেনজিৎ উইল সে।
ঠিক আছে ঠিক আছে ঠিক আছে, রেকর্ডিংটা শুরু।
হচ্ছে।
তো সাউন্ড আসছে কোত্থেকে? প্রসেনজিতের ফোন বাজ।
কি হলো?
তোমার ওখান থেকে একটা নয়েজ আসছে, দেখো। এই শিলাজিৎ, রেকর্ডিং স্টার্ট হয়ে গেছে।
হ্যাঁ, এখন আরম্ভ কর।
A very good afternoon to all esteemed participants, my colleagues, research scholars, and my beloved students. I welcome you all to
ভীষণ
the third
ব্যাকগ্রাউন্ডে নয়েজ আসছে।
Prosenjita,
হ্যাঁ, প্রসেনজিৎকে মিউট করো না।
মিউট করো না।
হুম, 1 মিনিট।
হ্যাঁ, thank you. So, a very good afternoon to all esteemed participants, my colleagues, research scholars, and my beloved. I welcome you all to the third session of the National Webinar Lecture Series on Biodiversity organized by IQAC in collaboration with uh, uh, the Department of Botany, Microbiology, Physiology and Zoology of Vijayagarh Jyotish Rai College. As we all know, we have organized this lecture series as a part of celebration of this year's focal theme of the World Environment means biodiversity. In the last two sessions, we had experts discussing about IPR and genetic diversity. Today, our expert speaker is going to deliver lecture on biodiversity and patent law. However, before moving to this session, I would like to request our one of the IQAC coordinator, Dr. Prosenjit Das, to deliver his welcome speech. Dr. Das, please.
Thank you, Shilajit, for anchoring. Welcome all the participants in this national webinar lecture series on biodiversity. As Shilajit already mentioned, biodiversity is the focal point of this year's World Environment Day, and indeed it is very important and part of our everyday life, I guess so. And patent law is very much related with biodiversity, and on behalf of Internal Quality Assurance Cell, Vijayagarh Jyotish Rai College, uh, I welcome our speaker, Dr. Sanjita Ganguly, who is a patent attorney at S. Majumdar and Company, to deliver her talk here on biodiversity and patent law. This is the third day and the last day of this webinar series. I expect this lecture is going to be an engrossing one about biodiversity and how it is related with patent law. Uh, where are the loopholes? How those challenges can be overcome? So this is a very vast area. Uh, I expect our speaker will enlighten us about this particular area of biodiversity, and which is quite not elaborated yet in many scientific forums. So this is going to be a new kind of experience for us. So with this brief introduction, I would like to request Dr. Shilajit Barua to proceed for the next part of this webinar. Thank you, Shilajit.
Prosenjit Das, for your wonderful speech. Now, next, I would first of all request all of the participants to please keep your microphone in mute mode to carry out the proper maintenance of the session. Firstly, secondly, please don't share your screen our presentation. Thirdly, the feedback form for the seminar or for this webinar will be given to the chat box. Will be posted in the chat box during the question answer session. So please don't forget to give your valuable feedbacks out there. And after this, I would like to call Dr. Gagi Shahakesh, Associate Professor, Department of Microbiology, to welcome our speaker today. Dr. Gargi Shahakesh.
Thank you, Shilajit. It is my opportunity to introduce my friend, Dr. Sanchita Ganguly. Dr. Ganguly has been an active patent attorney for over 18 years and heads the life sciences team in the firm. She drafts patent specifications and prosecution. She is also involved in drafting of patent oppositions and providing infringement and freedom to operate opinions. Associated in the capacity of faculty member with various organizations engaged in the promotion of IPR, including the Government of India, and Dr. Ganguly also serves as a guest faculty member in several institutions like the Technology Information Forecasting and Assessment Council, TIFAC, Rajiv Gandhi School of Intellectual Property Law, RGS, OIPL, IIT KGP. She is also a member of the APAA. Thank you. Sanchita.
Thank you, Gargi. And thank you all of you, the organizers, for arranging this webinar, which I understand would be helpful and to broaden our knowledge and perspective in view of biodiversity and patent law. Good evening, all of you. Now, please bear with me when I'm trying to share the screen because I'm not very much a tech-savvy person. Let me see how much I can do. Okay, not bad. So, here we are today discussing on biodiversity and patent law. Give me a moment. So as biodiversity is concerned, I'm not going to say what is biodiversity and how one should take care because I presume that the departments which are involved in this webinar, they are well aware of this. And what I propose to share with you is some knowledge on the patent law and how biodiversity is guided or the nuances of biodiversity, how it is captured in law of the National Biodiversity Act, and how the patent law interplays with it so that the inventions which are made by the applicants or the inventors are taken care with the same time our rich biodiversity is maintained and is not compromised. So with this, let me, I think this is, as I heard, this is the third of the series of webinars on this account, and you must have had some basic knowledge of what is patent. And without it also coming from scientific faculty, one would know at secret is, what the trade secret, that is what is the formula is, and it seems that only two people know this, and it's kept in a locker, and those two persons are not allowed to travel on the same day, whether by air or any other way. So that's beside the point. So now, when we come to patents, it is for a limited amount of time, that is, it is 20 years, and it is for a particular country. The country, it is very much territorial right, and you do not have anything called an international patent. It is not like that I file a patent and I get the right in USM, China, Japan, Russia, Pakistan, Bangladesh, India, everywhere. It's not like that. And for every country, you have to file the application for the patent, and each application and each country will review that according to its own laws and then grant or refuse the patent. So the disclosure part is very important, and that disclosure, what we called in the patenting parlance, is the patent specification, where the invention is disclosed, what you have made, how is it taking the science forward, how it is industrially applicable, and how to work the invention. So that is how you go about. Now let us look into slightly into the Biodiversity Act. Now, biological diversity is a great, what should I say, treasure of India, because
হ্যালো শিলাজিৎ,
Hello, Sampati.
please request Gargi to contact our speaker.
Hello.
Hello, please request Gargi to contact our speaker.
Gargidi.
গার্গিদি নিশ্চয়ই ফোন করে বসে আছে।
হ্যাঁ, কি হয়েছে? আমারই তো আমি কিছু শুনতে পাচ্ছিলাম না বলে বেরিয়ে গিয়ে ঢুকলাম। কি হয়েছে?
না আমরা না, ওনারটাই ডিসকানেক্টেড হয়ে গেছে, একটু ফোন করো।
আচ্ছা, ফোন করছি।
দিদি, মেশিন থেকে ওটা আওয়াজ আসছে কেন গো? অনেকে রিজয়েন করতে পারছে না বলছে, কিন্তু ওই দেখো
আমার মেশিন থেকে কোনো আওয়াজ আসছে না।
এটা একবার মিউট করো তো দেখি, একবার মিউট করো তুমি।
হ্যাঁ, আমার তো মিউটই ছিল এতক্ষণ।
এটা মিউট করো দেখি। ও গড,
দিদি একটু মিউট করো।
এটা একটু মিউট করো।
হ্যাঁ, আরে মিউট হতেও আজকে টাইম নিচ্ছে।
হলো না।
এটা এখন ঠিক আছে তো মনে হয়?
এখন ঠিক আছে?
ওখান থেকে কিছু একটা নয়েজ
হ্যাঁ, এখন ঠিক আছে।
কিন্তু সঞ্চিতা কি আছে?
না
না,
কিন্তু কি বেরিয়ে গেছে?
একবার দেখো তো।
হ্যাঁ, ফোনে পাচ্ছি না তো।
আমি করে দিচ্ছি তো, এখানে ঢুকতে হবে তো, না হলে একটু করা যায়।
Shilajit, hello,
হ্যাঁ
hello Shilajit.
হ্যাঁ
Please
সম্পাদি
request
বলুন।
our audience.
এই ওয়েদারের জন্য সিগন্যালিং এর প্রবলেম হচ্ছে।
Apologize to our audiences for this technical glitch. Our speaker will be joining shortly. You can well understand due to some technical issues or due to some network problems, our speaker could not join immediately. She is trying to join the webinar. So I'll be grateful if you please bear with us. Hello.
তো উনি এখনো ঢোকেননি বলে।
It is taking long time to rejoin. Speaker বলছে।
প্রসেনজিৎ দা, হ্যালো। প্রসেনজিৎ দা আদৌ আছে তো? হ্যাঁ
হ্যাঁ
প্রসেনজিৎ দা,
হ্যাঁ
বলছি স্পিকার বলছে জয়েন করতে পারছে।
হ্যাঁ, এখানে তো আমার কাছে কোনো রিকোয়েস্ট ঢুকছে না, মুশকিল তো সেইটাই।
হ্যাঁ অনেকে
এই যে ঢুকেছে।
ঠিক আছে ঠিক আছে।
আর ম্যাডাম বলছেন ইউটিউবে কি একটা আওয়াজ হচ্ছে তো।
হ্যাঁ, ইউটিউবে একটা শ্রীল একটা সাউন্ড আসছে, মানে ওটা কোনো ইন্টারফিয়ারেন্স হচ্ছে মোবাইল থেকে কিনা বুঝতে পারছি না। মোবাইলগুলো দ্বারা সরিয়ে দিচ্ছে, আমাকে কেউ ফোন করো না।
ঠিক আছে।
Sorry for this. I mean, okay.
Slide, I think.
Oh, Baba, slip. So I think we were discussing on the definition of biological diversity and biological resources and product.
Yes, ma'am.
Right. So here are the definitions which are given here in the Biological Diversity Act. So biological resources plants and microorganisms, their value-added products are those that can extract plants in unrecognizable but physically inseparable form. So now if we see at what the Biological Diversity Act has to say about the intellectual property. Right, it says that no person shall apply for any intellectual property, right, by whatever name called in or outside India, or any invention based on any research or information on a biological resource obtained from India. So if there is any biological resource which is obtained from India, then one has to seek permission from the National Biodiversity Authority, and the authority will permission and could impose a benefit sharing and royalty or both, or the condition include sharing benefit rights. So in connection with that, we can give the permission for using biological materials. Now if we see what is actually the patent, or what can be patented, or what is patentability, there are three cardinal features of patentability, that is novelty, inventive step, and capable of industry application, which means that the invention which we have made, whether it is a product or a process.
Excuse me, ma'am. Hello.
Yes. Yes.
Ma'am, please could you present your slide? Your slide. We are unable to see your slide.
Actually, ma'am, you have to again share it. It got lost.
Okay.
Present now.
Yeah.
Right. Yeah. Now it is visible now, right?
Not yet.
Okay.
Yeah.
Now it is visible.
Okay. So you have seen that Biological Diversity Act talks about what is biological material. It also talks about that if using biological material, you have to take permission from the National Biodiversity Authority. And with that, you move on now. What is patent? Or can be patented? What are the criteria? These are.
No slide is showing.
But it says Google Meeting is sharing the window.
Ma'am, I think it's you have to share the window of the PowerPoint presentation.
That's what I did.
Okay.
You're presenting to everyone. Stop presenting. What's that?
Yeah, could you stop presenting and again you can start from the
Okay.
presenting.
I stopped it. It is showing.
Gargini, are you on laptop?
No, I'm on mobile.
Okay.
Why?
Only thing you people will get bored.
What?
Take a slide, I can speak, but you people will get bored.
Yeah. That can be done. সেটাই বলছি।
আমি কিছু বুঝতে পারছি না কি?
কাকিদি তুমি একটুখানি স্লাইডটা একটুখানি ওনাকে দিতে পারো, তাহলে আমি এখান থেকে প্রেজেন্ট করতে পারি।
That's what I was asking. If you can mail to Shilajit ma'am, then he can do the slide.
You can mail it to me.
Give
You
me
can
your
mail it to
mail.
me. I can share it with Shilajit.
Okay, just give me a moment. I mean, I have never faced this type of situation.
That's why I was asking Gargiri whether you have laptop on or not. Thank you.
Just give me a moment.
Urmiti,
Yeah, Bola.
you are on laptop.
Yeah, I can do the same.
Could you share because I am having some problems, I think here.
I can, but I need to get the PPT right.
Yeah, Gargidi, could you share it to Urmiti, please?
Yes, once I get it, I will share.
Okay, okay. You share to Urmiti.
Sanchita, have you sent the email? Hello?
Yes.
Sanchita is not here, I think. She left the meeting.
Yeah, I think to send the mail she.
Yeah, that may be the case.
Ah.
This situation has never come before.
হ্যাঁ সেটাই। Ma'am, yeah, ma'am is there.
Yeah, she is here.
Sorry. I mean, I have never faced this situation earlier.
Yeah, this situation is new to us also.
Because maybe this is the first time I am doing on Google Meet. I mean, Zoom and this that WebEx runs properly, but I don't know today. Can you see now?
I can, yes, ma'am, yes, ma'am, yes, ma'am, yes, ma'am. We can see.
I'm not giving it the full slide because otherwise I cannot see what is going on. That is also a problem.
Surely,
Yeah,
ma'am. You can zoom it, ma'am. You can zoom it, and yeah.
Yeah. Let's see. Hopefully it goes away. So we were just saying that there are three cardinal features of patentability. It has to be novel. The invention has the product or the process. It has to be novel. It has to be inventive and has to be capable of industrial application. And there are certain statutory exclusions, like every country, as we said, that this is a territorial law, and every country can have its own way to protect or to make the law so that its interests are protected. Like things like method of treatment, it is not patentable in India, but it is patentable in the USA. Also, plants, animals, or parts thereof. So that's not patentable in India, but that can be done in US. So these are the statutory exclusions which go about when we talk about patenting. So what is or when is it called novel? That when there is no prior publication. So if you have a new thing, if you have a new dress or a new pen or a new phone, then it has to be new in the sense that the previous one is different from it. So similarly, here if you have found something new, you to call it new, there it should not match or there should not be any disclosure of it or any publication before you have made the publication or you have applied for the patent, or there is no prior public use. So if the use is in public, so you cannot patent it anymore. I mean, people may not be aware, but the use is in public. Like there was a very interesting case where somebody had invented a padlock, and it was actually found that a similar padlock was there in a gate of sort of depilated house, but the gate had that padlock, and it was on the road, so people were able to see it or use that. So that was in public domain. So anything should not be in the public domain to call it new, or it should not be on public knowledge. So anything which is not available to the public, it has to be compared with. So what you have invented has to be compared with what is available to the public or in public use. So you have to make a search. It's the novelty aspect is similar to writing a paper where you find something and disclose it in the paper. So, and then you have to do the search before that to find out whether something like that existed or not. But the next, so if we see that the prior art is here and the maroon part is your invention, so you're far away from the knowledge or the disclosure previously, and then it is novel. But if you lie within it, the red part in the green part, so then you are not novel, or that the product or the process is anticipated. Next, if we go, the next feature is inventive step. So when is it inventive? When the creation is not an obvious extension of the existing knowledge. So it is defined according to the Indian Patent Act that it should have a technical advancement compared to existing knowledge or have economic significance or both. So it's like somebody has made a composition with chlorine and you are making with fluorine. So it is very obvious that something which is which is known with chlorine, there is reasonable expectation that similar thing will work for fluorine also. So then that is becomes obvious. That test is for obviousness. So if the prior art is here and you are different from it, but the state of the art knowledge is at that time is joining these two. So they have made it with chlorine and you have made it fluorine, but the state of the art says that both are halogens, so they are supposed to provide similar effects. So then it becomes obvious and not inventive. So this is a case to explain what this inventive step is. That is, the invention or the prior art, actually, the Genentech claim covered natural sequences of naturally occurring TPA used for as a drug for dissolving blood clots. Now, Wellcome Group, they developed a modified TPA, which they named Fix, and that has 15% less amino acid, and it stayed in blood for 10 times longer time. So, if we see pictorially, the TPA of the prior art was this, it is active for X hours, whereas a Wellcome Group is they brought into light, it was 15% less amino acid, but it stayed longer, 10 times longer. Now, in the lower court, they were said that taken as equivalent. So you are using 15% of it, so it is obvious that this will also give an effect. So it was found obvious in the lower court. But when it went to appeal, they said that there is no motivation from Genentech that if amino acids could be reduced, the effect could be increased. So there is no motivation that if you reduce the amino acid by 15%, there will be an increase in 10% of the stay. So it stays longer for 10. The duration of this stay is increasing. So there is no motivation for that. Accordingly, it was directed, no, this is inventive and not obvious. And accordingly, the patent was granted. And the third aspect is the invention is capable of industrial application. That's the third cardinal feature, and it can so that it can be made or used in industry. This is an important feature of patent because when you have an invention and the statute is giving you monopoly, why is it giving? Firstly, it is to encourage invention, it is encourage the scientific researchers to go on, and also to encourage the industry. So something you are making which is industrially applicable, which could be made into large scale, made or used in the industry. So that is a very important criteria. Now, we had a case where the claims, as we say, because the patent specification is written in a way like a story, like what was known, what was the need in the field, and what the people did, the inventor did, and what we want others not to do. This what we want others not to do comes under claims. So I claim that this is my invention. So claim is like the boundary wall which you give in your house. So people, the trespassers know that this boundary wall, the within this boundary is X's territory or Y's territory or P's territory. So that is what the claims are for. So the case which I'm talking about, there was a claim for method of applying some, I think, some hair color or something to the hair. The patent office objected that this is not industrially applicable because you are just applying it to your hair. So, I mean, how is this can be made or used in industry? So, what we said or what we submitted was that now why are you thinking about a single person applying it to a hair, to his or her hair? Think of the larger scale because it could be used in the salons, it could be used for beauty treatment, and in the different salons and beauty parlors. So definitely that is a big industry and it has industrial applicability. So it is being used in those industries. So yes, there was a point in that, and the objection was met. Now, if we see that when we are talking of biotechnology and biological diversity, what could be the things which could be invented? So, a living entity, there could be living entity natural origin. You can find it for some time that this microorganism was not known, or that artificial origin microorganism vaccines, biological materials like part of DNA or the genes or a vector, or process relating to living entities, or methods of treatment. But all these are not patentable. If you recall, we had said that while we are talking about novelty, inventive step, and industrial applicability, we had mentioned that not all inventions which are novel, inventive, and industrially applicable will be patented because every country has its own way of saying that, well, I would not give this, that's my law. This one is in universal, that living entities of natural origin. So nobody will give you patent living organism which is already there of natural origin. Or any process of manufacture or production relating to those living entities of natural origin. Even if you're artificial origin in India, we are not giving that. Essentially biological process of production of plants, animals, or method of crossbreeding or something, that is not patentable in India. But living entity of artificial origin, like microorganism, vaccines, these are patentable. Then biological materials like recombinant DNA, plasmid processes manufacturing them, these are patentable. Gene sequences and DNA sequences without any disclosed function are not patentable. Just this sequence was already known and people perhaps didn't know. So it was already there. You just said that this is a sequence doing for this. So that is not patentable. It's if you are not doing for this also, that this particular organism has this particular gene sequence, which was perhaps not known earlier, and you find it. So that becomes a discovery. A discovery is not an invention which is patentable. A finding of an abstract theory is not patentable. In India, whatever I'm talking is in for India. But a process relating to microorganism for produce, suppose you find a microorganism which produces some antibiotic. So you find in the sense that you manipulate the genetic pool or genetic makeup of it to produce that microorganism, then you can claim that microorganism. Or if you are able to modulate this activity so as that it generates an antibiotic, so you can claim that that process where you have made the changes and the antibiotic. So this is how you can claim. But as a whole, if it is there in nature, you cannot claim your right or monopoly or patent in India. Now, any method of treatment, which is curative, prophylactic, diagnostic, whatever you call it, you cannot patent in India. A method of agriculture or horticulture, so not patentable. So you see that the patent law already had things which is trying to guard the biodiversity. So you cannot just take a microorganism which is lying there that it is mine, that I have found it. Fine, you have found it, describe it, publish it, well and good, but you cannot get monopoly in that. Now the whole idea, if you see, of patenting, because they're talking about novelty and inventive step, the idea is that you cannot prevent the public from doing whatever it was doing till now. Now, perhaps from this part of the country, I was using this soil from the Ganges basin, and we have been using this, and suddenly you come and say that this part of the soil has this microbes, I have found it, and so I claim a patent for that, and I prevent others from making, I mean, using that part of the soil or the from the Ganges basin. So you cannot do that. The people have been doing it unknowingly, knowingly they were doing it. So you have not done anything, that there is nothing your manipulation other than isolating. So that isolating part is not patentable. So if you see that the biodiversity is being maintained in a general way within the Patent Act itself, so it does not allow you to patent a living being. It does not allow you to patent a plant or animal or any parts thereof. So you cannot patent a cell. You cannot do that. You cannot patent a transgenic plant. You cannot. Even if you are making a transgenic plant, you cannot, because it is a whole, you cannot patent a totipotent cell because it is capable of giving rise to a whole being. You cannot claim a stem cell because it has life. So you cannot claim, or that is, you cannot patent this, you cannot claim your monopoly on these things. So this was already there. I mean, Biological Act or Biodiversity Act may have come later, but the fact that the lawmakers had kept the biodiversity part as non-patentable or something where you cannot claim monopoly was already there. And then another very important aspect from Indian perspective is traditional knowledge. So anything which invention is a traditional knowledge or aggregation of known properties of traditionally known properties or aggregation of that, so you cannot patent. I mean, you cannot come and say that I am getting antibacterial effect with haldi and I will patent it. No, sorry, it is known. It's a traditional knowledge. Now, this is something for the history. Louis Pasteur was awarded the US patent 141072 in 1873 for a yeast. And this is a very important case, which perhaps we all know about, Mukha Chakrabarti versus Diamond, because he found a genetically engineered Pseudomonas, which is capable of breaking down four major components in crude oil. So if there is an oil leak and spillage on the sea, and if you use this bacteria, it will take away those crude oil and purify the water. So this was a historic invention and a historic judgment given by 5:4. So there were four judges who were opposing it, and five judges which were for it. So it was a very neck to neck contested matter, and it's regarded as one of the great judgments in the history of patenting. Now, patenting life forms. Well, patenting movement take many turns. When patent number, US, this patent number claimed transgenic sheep, we know about Dolly. So after that, many things have been patented: pig, a sheep, goat, cattle, mouse, human antibodies, and so on and so forth. But in US, not in India. This reminds me of one of our clients. I think he was from CCMB or Hyderabad, someplace. So he had found a very, I mean, he had invented, he had made a transgenic sort of rat which was obese. Interesting. It was obese rat, and it was a very good model to study effect of anti-obesity drugs. It was a very good invention, but we suggested him that good invention, but sorry, we cannot have it patented in India. You can apply in US and try, because it's a good invention. So that's it. That's how one has to go about to think. Now, when we're talking of biological material, the patent law, it requires that, as we said right in the beginning, that the invention has to be described. And with that, because after it goes off patent, others can use it. You must be hearing about that. Even Pfizer is now running, I mean, in the ebb, but we should say, because a lot of their patents of molecules are going to be off patented in 2022, 2023, 2024. And they do not have many pipeline molecules. So off patent means 20 years you have enjoyed the monopoly. After 20 years, it's become public, so others will be able to sell it at any price. Whereas because you have invented, your price is high because you have put in the full R&D behind it. So naturally, your price will be high, whereas the competitors who have come to know about the invention and they are making it following your footsteps, they can give it in a lesser amount. So that's the problem when it goes to off patent, and it is the plus point for the patients or the general public if it is not related to pharmaceutical. Is not patient, but is the general public who is, and that's the, what should I say, that's the basic quid pro quo of patenting. Now, when you're describing the invention, now you have found or you have made a invented a biological material. Some inventions have gone into the microbe, so you cannot describe it as such. So what is required then? You have to deposit the material with the International Depository Authority, and this is after the Budapest Treaty. There are many countries who are among them, and there are internationally known or internationally accepted depositories where you have to give it, and after your patent is published, that uh, uh, microorganisms or that biological material is also made public, so anybody can use it after taking your permission. So in India, we have two such places where deposit can be made. One is microbial type culture select, that is MTCC, MTech, and the other is the MCC and the Pune. Now we come to inventions relating to also biological material. The other one was that you have invented the organism or you have invented certain biological material which is a living thing, and you have to deposit. The other thing is that you are using a biological material already available. You are making some changes on it, and you have used it for research, as we read from the Biological Act, that if you are using it in research, some biological material or knowledge of some biological material, then you have to seek permission. The first thing is you have to give source and geographical origin. Now, if it is from India, you give the source, and then if have to take permission from NBA. If it is not from India, you just give the source from it. And there's an appropriate declaration has to be provided on the patent form. And in case, as we said, biological material from India, we have to take permission from NBA before the grant of patent. And then, as we already saw when we were dealing with the Biological Act, Biodiversity Act, sorry, that royalty and benefit sharing may be imposed by the National Biodiversity Authority. And it is very important, like here is what we were trying to say when we are looking at the National Biodiversity Act, that the government has tightened its grip so that, I mean, unauthorized use is not done. So if that is what it is, there is a punitory provision. It says that if permission is not sought, provision of penalty of or imprisonment, penalty of imprisonment of up to 5 years, or with fine up to 10 lakh rupees where the damage caused exceeds 10 lakh rupees. Such fine may commensurate with the damage caused, or even both. I mean, one can be uh, given imprisonment as well as fine. And in case biological material is not from India, you have to give the source and origin. I mean, we have such laws in place, but unfortunately, we all know, I mean, the implementation is not so good. Otherwise, that person with fat mustache wouldn't have run almost 2 South Indian states. Finally, he was killed. That is the sandalwood king. We all know. So next, because we have lost some time, I'm hurrying through this. If I'm going very fast, please tell me. I'll just slow down the pace because there are a lot of time wasted. So I'm going a little fast. If that is okay, then I'll continue, or then I'll go. Otherwise, I'll go a little slow.
No issue, ma'am. It's okay.
Okay, fine. So here we have that when we are using biological material, as if you recall that while describing the definition of biological material, we say that which is biological resources are those which are, or we cannot use the parts of the animals then this, except the and plants except the value added. Now the thing is, what is value added? Though the law says it's very clear that you have to get it in physically unrecognizable form, but that is not very well imbibed by the people who are actually running the show. That is the tragedy of India, that we have all the laws in place, but the implementation is a little crude, if I may say the least. So these people who are running the show or who are looking into this, I mean, they are not sort of applying their mind whether to say that it is really a biological material or is it a value-added product. Or I mean, one has to apply its mind, because when you're talking about an invention, a lot of, we all know, though most of you are from research and academics, so you all know that how much time and effort goes into research of finding something and bringing it to a level of a product. Almost, because when you are going for a patent, you have to show the industrial applicability. If you're going for a medicine or a pharmaceutical product, you may not have tested clinical trials. It's not possible before applying for a patent. But then you have done a lot of in vivo testing to find that it really works. So all that will go into vain because somebody who is looking into it, that you have used somewhere 0.0005% of a flavor in the composition. Maybe you have used vanillin flavor in the composition, but unfortunately he says it's vanillin. But never applies its mind that if I have to take vanillin from vanilla plant, I will have to invest a lot of money, because to grow or to get the vanillin, because vanillin is not so well grown in India. So if I have to do that, I have to for 0.05% flavor. I will invest so much. My invention is not in the flavor. Maybe I have found a face mask or a face cream. So naturally, I'll use an artificial flavor which is having a very artificial flavor. So that thinking or that application of mind is what we find is little lacking when adjudicating the inventions which are borderline. So that is where we need awareness. We need awareness from general public to see the least, that when somebody, even if the biodiversity settles, before imposing the royalty, they probably should call for a hearing. You can always go and say, ask for a hearing and say that you do not think this is a biological material because of this reason. But the fact remains that you don't have a taker to listen to that, because lack of training. The down the line people, the top people may be well trained, they are well known, but the down the line people, they're not so well trained to look into it. So there I think there should be more awareness as to how to look into the things. I mean, one should apply his mind that why should I spend so much money, because this is only a flavor into my face mask or face cream composition. My invention is not there at all. So that understanding is lacking, which we find when we are going in from patenting, because I had visited the National Biodiversity Authority office in Chennai. It is in electronic city, Chennai. So unfortunately, I couldn't visit the chairperson. I couldn't meet him. He was in a meeting. I met a junior officer. A very, very, very unfortunate that he took my card and said, "Okay, fine." Then he started to look into the patent office website to find out some applications where I, as a patent agent, I have signed and all. And then he found out you and said, "You haven't taken permissions for this." So then I was explaining to them that those are only synthetic materials. I don't need permission. So then that is what we find is that it's a shortcut, because in India, we have very two extreme people. One extreme is that people who are very methodical, very uh, energetic, very methodical, and they want to learn and they know what they are doing, and they are thorough in their work. And the other is the shortcut. Okay, control F, find out oil. Oh God, you are using a biological material, you have to take permission. So that's not it. So the thought process that needs to change, that application of mind has to come. So this is a case where 4228 colon P 2008 is a patent application. The invention was to find the molecular weight aminoglycan extracted from waste eggshell. So they have used waste eggshell, and from there they have used the aminoglycan. They have extracted and the composition are components like sandalwood oil and in what happens with patenting, you as an inventor, you write the patent, as we call the patent specification, or we as patent agent help the inventors and applicants write, and then it is submitted to the patent office, government of India office, and that is has to examine. For examination, you have to pay another fee. So you have a filing fee, and then you have our examination fee. So there's time limit also. So, and after that, the patent is examined. So as we were just saying, novelty, inventive state, capable of industrial application, and then whether it is well described or not, whether it is falling in the exclusions, that is the method of treatment or plant or animal body or parts thereof, or is it a naturally occurring thing, so on and so forth, they will examine. They'll also examine that if you have a biological material used, whether you have taken, is it from India? If it's from India, then you whether you have taken permission or not. So that also you have to say. Now this case, so after this examination occurs, you get an examination report and you have to reply to that. That is also time bound. Within that time, you have to file a reply. After that, if the patent office can send another report or directly calls for a hearing, whether the patent agent or the sorry, extremely sorry. Where the patent agent or the applicant visits the patent office, or nowadays we have to do through VC, and then we sort out the case sitting across the table or across the computer to sort out, to find out what his or her objections are and where we stand and how these objections can be made, whether some amendments can be done or something. So in this case, after the reply, the controller was not happy, and then she, or I don't remember, he or she, whatever, the controller was not happy. He asked for a hearing. Now it was said that these people had taken the oil from US. I can might as well do it if I have a collaboration research. My US counterpart can give me the oil. No, I mean no problem with that. But also we had case where that was also problem. Somebody came. I mean the controller said, I mean if you're taking it from outside and the cost will increase. We said, I mean how does it matter? At first you grant us the patent and then whether the cost part will come in. Anyway, so that is also, but that question is also raised that why are you taking it from outside? It is found in India. So, I mean, in India, we even have the sticky notes made in China, which is going on. Why sticky notes? Even the Sri Ganesha idol are coming from China. So people are bringing it and using it here. So what is the problem? Well, so that's besides the point. Now here the oils were taken from US. And the eggshell waste was from processing industry. They clearly given that it was taken from Venki's. They had this waste eggshells, and it was taken. But the controller said, but it is a biological material. We said, I mean, it is biological material. I mean, there has to be exhaustion. Somewhere one has to end. Either the egg is hatched and the chick is going out, or you are breaking the egg and taking cooking it and disposing of the shell. So I have taken those from Venki's where they have used the egg for frying something or making anything. I mean, I can might as well take from the egg roll people who use so many eggs and the shells can be taken. So that is a waste. So it was continued and we showed them about the waste processing, that is the solid waste management rules, where it was clearly said that waste management is a challenge, and how to manage waste, and in that among the list of waste, the catering waste was also there. So we said that look, this is a catering waste. And then we also have national biofuel policy where it says that from animal waste and feedstock you can have biofuels. So that is also being done. So nobody is saying that you don't use the waste. Now, I mean, where does biodiversity end? Because if you see the basis of the Biodiversity Act is sustainable development. So, I mean, where is my sustainable development hampered if I am using the eggshell, which is waste? Now, tomorrow, if I make a biofuel from cow dung, you will ask me to take permission because I have taken cow dung. I mean, this is ridiculous. So ultimately, anyway, this was sorted out, and the controller was convinced that, well, yes, it is waste material, and then it is not a biological material for which permission from the NB has to be taken, and the patent got granted. So we get many such cases as down the line. There were cases where extract from algae was taken, and then chemical was added, and that was used in a anti-aging composition. Now this controller, he found out that this particular algae is not from India. He found that, I mean, it's not found in India, it is found in Philippines and all. He said, okay, we are convinced it cannot be from India. So, okay, fine that it's outside India. And then what about the other component? This component is found in grape seeds and all. So that's a biological material. So how do you go about? Then you have to take permission from the NBA and you have to respect it. So we convinced him that no, this is not as such. We are not taking from grapes seeds. We are taking the synthetic compound and then we are using it. I mean, and then there was another problem because this was tested on a microorganism because it's anti-aging. So it was shown that when you're testing with this on this microorganism, it lives for a longer period of time, which goes to show that it has some anti-aging effect. Now now here you are using it. So we submitted that this is like using a laboratory animal. I mean, we are testing in vivo testing to do it. So my invention is not based on research on that. I am showing that my invention is workable on this as a experimental. So then he was convinced and he said, okay. Now we also had cases where guar gum, sucrose, these were used and they said that these are biological material. We tried to reason out, I mean, can you think of the folly of, sucrose? I mean, can you think of taking sugarcane, crushing them, taking the juice, then subjecting it to drying and then finding the sucrose and then using it in a composition? I mean, why? Why should somebody do so much? And guar gum, can you imagine? It's used as a binder. In agarbatti, it's used as a binder. In many, even in tablets, it's used as a binder. So why should somebody take it from the gum plant, extrude it from the gum plant, and you might as well order somewhere and they'll give you the synthetic one. And things like beta carotene. Beta carotene is sometimes used in this night creams and day creams. They use beta carotene. I mean, why? I mean, think of the feasibility. One should think about the feasibility that bringing so many of carrots and getting extracting it and then counting down to the beta carotene only and then using. I mean, this is a very, 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 very far-fetched idea. I mean, one would just give it an order and Sigma will deliver beta carotene. So, what is the problem? So these are the things. Here, as we were saying, that there are some borderline cases which needs the understanding, which needs the thought process in the line to think. Not one cannot do blindly. Control F, you have this, so it is falling. It's not like that because patenting itself is a highly technological area guided by the legal provisions. So it's a technological document as it is we call the patent specification. And then the value added product. Now, when we are doing some value addition to it, the law clearly says what are biological materials, resources, they exempt the value added product. So there is exempted because there is some human intervention. Now, if you go and think that originally it had come from this, so then that question will remain forever. What came early, the chick or the egg? So, and if you are asking for National Biodiversity Authority permission from them for deposited strain. I mean, the whole idea of Biodiversity Act is to sustainable development, protect our biodiversity. So if I have deposited the strain, there is no chance of getting it depleted because it is being maintained in the depository. So if I have found the strain, deposited it, and then used in some products, so how can that attract biodiversity? Because I have made it and deposited it. So, and even if I have not made it and taken from the depository, so I have taken from a depository and used it for some other purpose. Sorry. So if I have taken from the depository, it is being maintained there. So there's no question of the biodiversity being depleted. So these are the things one need to understand. Now, here is a patent application 1728 code 2007. This is for a process for production of biodiesel from jatropha oil by improved stabilization of enzyme for preparation of the bioil. Before this, according to the inventors, that the transesterification reaction can be carried out in presence of an enzyme with improved stabilization of the enzyme. This particular thing was not known. And they had used a particular strain, the lipase from a particular strain, Enterobacter aerogenes, and which was used for the first time for such transesterification studies. And another important feature was that they had used a solvent which dissolves the methanol as well as the byproduct glycerol. And this because the byproduct was shown to inhibit the lipase activity during biodiesel synthesis. So that was prevented by use of the particular solvent. So they have used this tertiary butanol solvent which is also so this was the invention, and it was described along with the prior art. That is what was known before that. And then, as we said, that it went for examination and what we call documents were cited out of document one, we call it D1, and these two are very close. So what did this documents teach? They taught that the enzymatic transesterification of oils. The D1 document, it talked about transesterification of oils and vegetable oils specifically, and it had an organic medium. It had, but the lipase was from yeast, and the organic medium was used for dissolving the short chain alcohol, not the byproduct. And the D5 was their own document. It also talked about formation of biodiesel and by transesterification of oil, and interestingly, jatropha oil. But it had done in a solvent-free system, and the lipase was also from a different organism. Now, this document was very close. Because too close to be, give you a happy feeling. So what happened that like you are required to give data in the specification. There's a patent document which is submitted. Which later this is from the lab or lab, whatever. You can give additional data to compare with it. So what the form of affidavit? That a person either or from somebody in the lab, one of the inventors or other research fellows or the guide or whoever, senior scientist, junior scientist, whoever, in an affidavit saying that I had done these experiments, I'm doing the experiments and giving that detail to show the difference. So here they were able to show that the difference with D1 was that it had used vegetable oil, and these people were used jatropha oil. Jatropha is not an edible thing. It is actually it is carcinogenic to some extent and is also toxic. So nobody would. And what is inventive step? It's like people. How it becomes obvious that when I read this, I will try with an obvious alternative. So somebody who has done this transesterification in vegetable oil would not be motivated to try in jatropha oil, which is not an edible oil. One can use alternatives. It's obvious alternatives, but not something so divergent. But then the D5 document was closed, which taught about use jatropha oil, but it talked about solvent-free system. So the submission was that when you are combining, because when you are talking about obviousness, you can combine documents. As if you recall the illustration which we were showing, that the big circle was the prior art and the small circle was the invention, and there was an arrow in between which was state-of-the-art knowledge, which is joining it. So state-of-the-art knowledge can join it or some other document. So you can combine 2-3 documents, more than one documents, to make something obvious. But when you're talking of novelty, it has to be, all the features has to be found in one document. You can take separate documents but cannot combine them. But for inventive step, you can combine the documents and say that it is not looking inventive. So here the controller did the same. He combined. He said, okay, fine, you are taking jatropha. D5 itself talks about jatropha. So instead of vegetable oil, if I combine these two documents, instead of vegetable oil, I take the jatropha oil. So next, our submissions was that fine, if you do that, is well and good. But then you see, D1 talks about solvent. D5 talks about such solvent-free system. So how can somebody who is joining the documents would join a solvent system with a solvent-free system? Those two are opposite. Either you choose solvent or you choose solvent-free. So how can you combine them? Now, even if we combine, for argument's sake, even if we combine, Then where do you get the lipase from? Because one is the yeast, this is a bacterium. D5 uses another bacterium. So this particular bacteria is not known. And then further, why we needed the affidavit was that the inventor showed that the jatropha oil, which was used in D5, has a different constitution. The fatty acids were different. That had more of oleic acid, this has more of linoleic acid, and there were some fatty acids which were not here and which was present there. So the combination of the fatty acids in the two oils are different. So naturally, one would not be able to combining these two. They might have tried jatropha oil as in D5, but not another jatropha oil which is used by this. So that was convincing. And finally, this is a claim, as we say, so the monopoly is given on this. So it is a process for preparation of biodiesel from jatropha oil, process comprising adding an alcohol to the jatropha oil, adding solvent, adding immobilized lipase of endo. Now, the underlying part is the part which was amended later. Initially, we had just said adding lipase to the said mixture. Now, when these documents were cited, then we pointed out that this was there in the later, because what we do that we want to give the broadest protection as long as it does not fall into another document. But if we find another document close by, we have to narrow the scope. So here, similarly, the scope was narrowed by putting in the reference to the Enterobacter, the specific organism from which the lipase was taken. And then it was also put in, this was also there. The solventizes interact chemicals with the lipase. As you saw that we said that it both the alcohol as well as the byproduct glycol that is dissolved by the solvent and thereby minimizing. So in view of all this submission, novelty, inventive step, etc. was met, but the objection was this. Remained is that biological material jatropha oil has been used. Attention has been drawn to invite Section 6 of Biological Diversity Act, which mandates that if a biological material procured from India is used, you have to take permission. If it is not from India, you have to give the disclaimer, it is not from India, from such. Now here is a case, yes, we have used a biological material. It's not a value-added product. It is not a synthetic thing. It's a jatropha oil from nature on which this biodiesel has been developed. So the request or the application was filed before the National Biodiversity Authority for granting permission, and they did grant permission within a short time only they granted. So this is I have just cropped few portions that NBA hereby grants approval for filing this. The specification is attached. And then he says that limited to the granted by NBA and this prior approval, but you have to use it, then prior approval has to be taken, and this benefit sharing, they have given certain percentage, whatever. This has to be. So this was signed by the applicant. And then finally, the patent got granted. Now, do I have any much time, or the whole evening of Saturday evening, I am boring you people to the extreme with such if you have some time, then I can go.
Okay, it's okay.
Okay. So I'll just go to the next slide. This is, what should I say, allied subject, that is traditional knowledge. Because if you see Biological Diversity Act, it says use of biological material and knowledge related there. So traditional knowledge comes with it. So we have a very rich biodiversity and very rich traditional knowledge. So we have a lot of knowledge with regards to many plants, their activities. Right from the Sanjivani plant, which was used on Lakshman in Ramayana. So we have a tradition, long tradition. So here this was a case where pharmaceutical composition and process for preparing plant extract for treating skin disorders and enhancing healing wounds. It was filed by an applicant from Taiwan. Now it had two parts mainly. One is preparation of extract of Plecanthrus aborigines by specific extraction method. So that extraction method was very important. They had given various steps, and there was no prior art in that. And then also they claimed a composition with this extract, Plecanthrus extract, which they prepared, and another extract of this plant was Centinella asiatica, and that was for wound healing. This application went for opposition. Now, in patenting, you have oppositions. It's like I filed the application, it gets examined, then it can get granted. Before grant, somebody can file an opposition that this patent is not good enough for grant. This is not novel, not inventive. They have not talked about, they have not given the source of the biological material, or if it is from India, but they have not taken permission. So, on the many grounds, they can oppose it. Even after grant, there is provision of opposition, that is a post-grant opposition. So even if you clear that hurdle and the patent is maintained, say for 4, 5, 6, 10 years, then also there is a provision for revocation of the patent. So many years down the line, somebody files a revocation saying that this patent was granted, but it should be now revoked because I am giving you this documents by which it says that it's not novel, it's not inventive, and it does not describe the invention well. It is not useful. It is not. Um, it's not industrially applicable. It has been prior used. There is prior traditional knowledge. He is using the traditional knowledge, and so the patent can be revoked. So the statute has given so many guards so that when a monopoly is given to for 20 years to somebody, there are so many checkpoints to see that he is really eligible for that monopoly. So here in this case, we have a pre-grant opposition that the examination was over, it was found okay, somebody filed, somebody, it is CSIR itself, it files an opposition saying that, citing so many TKDL documents, saying that this is in effect traditional knowledge which the patent is going to claim, and if you're giving it a monopoly, you're giving monopoly on Indian traditional knowledge. So that was the opposition. Now the submission from on behalf of applicant was that the main portion of this invention is extraction from Plecanthrus. That is not there in any of the cited TKDL documents. The TKDL documents were only for Centinella asiatica. And there was nothing on the combination. So it cannot be said that I am using the traditional knowledge. It is not in effect the use of traditional knowledge as such. Because the traditional knowledge, the articles which were cited, none of them talked about Plecanthrus, none of them talk about the combination. And very interesting, this patent applicant, in the patent application itself, it has shown that when you are using Centinella asiatica, it does not have effect on wound healing. It had other skin benefits, but not wound healing. And Plecanthrus did not have any effect as such on wound healing or anything. But when you are combining these two, suddenly you are getting a wound healing effect, and it is for a long period of time. Especially, I think it was for burn wounds. And it was very long period of time that wound healing was there. In the sense, I'm just saying that within a short time, the wound healing was high. So this part is not there in the traditional knowledge document which have been cited. So you cannot say that this invention, which is being claimed in this patent application, is the use of traditional knowledge as such, or you cannot say that this application is trying to monopolize the traditional knowledge of India. So this was accordingly found to be novel and inventive, and patent was granted. I think I come to the end of my slides with that. Yes. Thank you for your real patient hearing and bearing with so many glitches. And if you have any questions, I think you can take those. Hello? Hello?
Shilajit, ball.
I think people must either they have put in to sleep with such a boring
No, ma'am.
topic on a Saturday evening. Any questions?
Yeah, ma'am, thank you for this illuminating and informative session. Now, with your kind permission, I'm Urmi Roy, Assistant Professor of Vijayagar Jyotish Roy College. We'd like to go through the questions we got. Shall I move on?
Yes, please.
Okay. The question comes from Shilajit Barua. He is asking, what is the basic process for the flow process of patenting a bioprocess, like a biofilm produced from some EPS producing microbes for metal absorption, and what is the price of doing so?
Now, this is when you're doing it for metal absorption, this is a process. So, what the mechanism or the way of getting our patent is that application has to be filed. There's a particular form, and along with it, you have to give the description, what we call patent specification. And along with the fees, it has to be submitted to the patent office. The fees for individuals, I think it is 1,600, and for applicant as a legal entity, it is 10,000, I think. Yeah, and if it is, yeah, so that's the filing fee, and then you have to do the exam, give request for examination, which is 20,000, and I think 4,000 for the individual, 20,000 for the legal entity. Individual startup and the small entity, they have this lower grade, that is 1,600 and 4,000, and the higher is for the legal entity if a company or limited liability company is the applicant. So the process, yes, yeah, it can be done because you are talking about you're making changes in the microbes, and you are able to show that it is, having effect on the metal. So it can be patented as far as whatever I could catch from the question. I mean, you can do it is as such. The process you can do because you are not claiming the microorganism as such, and in the process you are using the microorganism. If it is microorganism which is directly taken from Indian waters or Indian soil, then of course you have to take permission from the National Biodiversity Authority. Or if it is a deposited strain, then you don't think it is required for permission.
Okay.
Hope that answers.
Yeah. Nicely explained. The next question again from Shilajit only. We cannot patent an organism, but can we patent a bioprocess by utilizing a non-patentable component?
Bioprocess you can, microorganism also you can, but if it should not be available in nature. If you can modify microorganism, you can patent it. Process, of course, you can patent.
Thank you, ma'am.
Okay.
These are the two questions, ma'am. So we are done with this discussion session. Now I am handing over the mic to Shilajit.
Is there any question in YouTube, Shilajit?
I'll
No,
have a look.
no question.
I think
No, in YouTube there is no
there are
question.
no questions. So I think we have come to the end of the session, and we will now proceed towards the Thanksgiving session. I'll request Dr. Shashwati Gayan to proceed with the Thanksgiving session.
Hello, am I audible?
Yeah, you are.
Yes.
Good evening. We have reached almost to the end of today's session and also to the end of 3 days lecture series on biodiversity organized by Internal Quality Assurance Cell in collaboration with the Department of Botany, Microbiology, Physiology and Zoology, Vijaygarh Jyotishree College. And I'm asked to propose the vote of thanks. At the very onset, I would like to thank Dr. Shonchita Ganguly for delivering such a wonderful and interesting talk on biodiversity and patent law. I'm sure all the participants have acquired necessary information about patent law. Thanks to our respected principal madam, Dr. Rajyashri Niyogi, for always encouraging and inspiring us to organize different kinds of programs for both teachers and students. Thank you, madam. Congratulations to all IQAC members and faculty members of Department of Botany, Microbiology, Physiology and Zoology for organizing this lecture series on different aspects of biodiversity, which is a very relevant topic and also the theme of this year's World Environment Day. Finally, I would like to convey my sincere thanks to all the participants for joining our webinar and bearing with our technical glitches. And we are extremely sorry that many participants were unable to join us due to, I think, network problem and bad weather condition. However, thank you all and good night.
Thank you.
আচ্ছা, অর্গানাইজাররা একটু থাকবেন।
Okay. আমরা রেকর্ডিংটা ইউটিউব স্ট্রিমিংটা বন্ধ করতে পারি?
হ্যাঁ, অবশ্যই।